You have described the reaction to the Cowichan decision as both loud and misleading at the same time. There is a concern that the decision will create a new law, that it will somehow supersede private property ownership or fee simple in this province. That is not the case, though.
Yeah, I mean, it's understandable, I think, that residents or even British Columbians might be concerned. I think especially because of the very alarmist language that we've been seeing from political leaders across the political spectrum. But if you actually look at the case, the Cowichan versus Canada case that was decided recently, it was very clear that the issue is between First Nations, who are title holders, and the Crown vis-a-vis the government, and that it is a responsibility of the government to resolve the various interests at play. It was never about the individual private property owners. And if there is an area that has been declared Aboriginal title lands, that it's a responsibility of the government to negotiate in good faith with the title holders, the Indigenous title holders, on how to reconcile those interests.
And a negotiation presumably would not mean handing over the private property of those individuals affected.
Well, I think this is also something that's really been missing from the conversation. The Cowichan Alliance that brought the case forward was very clear within their legal arguments that they were not pursuing any kind of judgment or relief with regard to the private property fee simple interest. They were focused specifically on the land titles that are owned and possessed by the government, whether it's the federal government, provincial government, or municipal government. And they were very clear that they were not interested in trying to go after or make a decision around the fee simple interests. And the courts went through a long explanation that that was the case.
Let me ask this next question colloquially. Why is everybody freaking out?
Well, politics is about being seen to do the right thing, if not doing the right thing. And I think that there is a lot of politics to be played here, whether you're a conservative or whether you're the premier of the NDP. I think a lot of political leaders don't want to be blamed for any hardship or any frustration. They don't want to be at the back end of any anger that might arise from this. And so there's a lot of finger pointing, there's a lot of deflecting, there's a lot of misrepresentation happening, as opposed to calmly and confidently explaining to British Columbians that the issues that are coming out from this case have been long overdue. These have been established through various court cases going back to the 1970s, over 50 years of Aboriginal title cases that have been trying to resolve this issue. But it's really, the courts have been clear. The Crown has a responsibility to negotiate in good faith to resolve these differences. And so far, it hasn't done that in many cases.
You are a member of the Squamish Nation, or you are a member of the Squamish Nation, or pardon me, you are a member of the Squamish Nation. You used to be a member of the council. We've seen the recent reclamation and development of the Jericho lands in Vancouver. We've seen the Sanok development as well on an old Squamish village site. The Three Nations, MST, the development company, have navigated more than one claim and building project. Tell me how the Squamish were able to do that, and is what's happening in this Musqueam, in this other case, is it analogous?
It is, in a certain sense, that, one of the questions that's been asked to me, and I think is a question that many British Columbians might have, is, well, where else might Aboriginal title be declared? Where are other areas in the province that this might become a concern because Aboriginal title has been declared or recognized, and it requires the Crown to then negotiate with those interests? So all of Vancouver is claimed by Musqueam, Squamish, and Tsleil-Waututh as a part of our Aboriginal title area. But what that means in practical reality is that the use and benefit of lands should be derived to those First Nations, and that can look like a lot of different ways. One of which is if there are title lands that are no longer available to the First Nation, maybe there are other lands that the Crown owns and possesses that could be transferred in lieu, or maybe there's financial compensation that could be given, or maybe that there is a benefit from things like provincial property transfer taxes or property taxes or development levies that would be shared with First Nations as a part of that recognition declaration of title. So none of those would impact the ability for a private property owner to be able to buy or sell or use their private property. It would continue as is, but it would be on the Crown to recognize and affirm and then to deal with other ways that First Nations can benefit from the lands that are technically based off of the court decisions over numerous decisions are belong to First Nations who have been able to prove title to that area.
Yeah, you have heard what political leaders have had to say about this, and as you say, some of them, spreading misinformation. Yesterday, we heard from BC Conservative leader John Rustad, who says this causes tremendous uncertainty because you have a piece of property that is in question. Why would anybody want to buy a home if the validity of the fee simple ownership of that home is being questioned? He also said, the Indigenous nations in this province claim 110% of the province. How should politicians be talking about this?
Well, it is challenging because these legal decisions are sometimes complicated and complex, and our education system might not do a good job of educating the Canadian public around what these concepts mean, like Aboriginal title, like the honor of the Crown, and so there's a lot of education that needs to happen. Unfortunately, as an example, Restad is sort of claiming that, and others are claiming that this is going to create uncertainty. Well, the reality is, going back to the Royal Proclamation, which was a Crown declaration back in the 1700s that recognized Indigenous title to land and said that as Canada was to expand westward, it had to obtain permission or treaties or agreements or purchases of land in order to settle that. And the Delgamuukw decision recognized and affirmed that the Royal Proclamation is a basis for Canadian law. And then that has stemmed into other decisions that recognize that Indigenous people own title and lands. And so there's these decisions that have come through, and unfortunately, you have a Cowichan decision that has come through, and you have political leaders claiming that this is going to upend some sort of system, when in reality, the uncertainty has always existed. It's existed for 150 years. The courts have repeatedly said the Crown needs to behave honorably and it needs to negotiate in order to resolve these things. And it's actually because the government has refused to do that work that we're in the uncertainty that we're in now. And so there's an opportunity. So as an example, practical example, there's all these arguments that province is going to appeal the decision. There's a desire to bring it all the way to the Supreme Court of Canada. That's going to take 2, 3, 4, 5, 10 years. Whereas the alternative path in many cases across the province is, wait, why don't we negotiate a deal now? Why don't we negotiate an agreement that settles this issue in a year, and then it settles it, as opposed to taking it through all the way to the courts? And so there's, I think, this political desire to politicize this further than it needs to be, as opposed to explaining the simple facts.
Khelsilem, it's really good to hear you this morning. Thank you very much for taking the time.
Thank you.
Take care. That is Khelsilem, a former elected member of the Squamish Nation Council, past co-chair of the UNDRIP task force as well.